concerns about remembering or giving wrong information. Well, that's also true of many witnesses when they're asked to give evidence about things that happened a long time ago, and that's really a matter for the Commission and for we, members of Council, to make sure we ask our questions in a way that will perhaps minimise that. Similarly, with the idea of or the issue of perhaps he's only able to maintain focus for a couple of hours, again, that's incumbent on Council to be very succinct and careful with their questions. And also, obviously, for cross-examiners, we can very much be suggestive about the answers, and a matter of the Bishop simply saying yes or no, or I don't remember, or so on. So a lot of the problems referred to in this report can be managed by Council, and it's appropriate that we do. Now, I've been having some discussions with Mr O'Brien, and we thought that one option here is the possibility of a private session under Part 4 of the Act. Initially, that's something that could be done at the nursing home without any technical.
The private session would only be a commissioner talking to the bishop.
Yes. Would it be possible that anyone else, that the Commission would authorise anyone else to be there?
The Act wouldn't allow it.
Perhaps I'm wrong about that. My understanding was that the Commission could authorise other people to be there.
Well, yes, but in contemplation that those are people assisting the private session, not the interest that you have in mind.
Yes, all right. I'll accept that.
So it can't be published either if you look at the Act.
Yes, I understand that. Yeah. Yes.
So
it could be contended by consent, I suppose, afterwards. But
no,
I understand the difficulties of that. I'm simply perhaps.
I don't think that goes anywhere, I'm afraid.
All right. Well, we're simply trying to explore all avenues, I suppose. So the one that remains is perhaps somehow doing a link from
anywhere, I'm afraid.
All right. Well, we're simply trying to explore all avenues, I suppose. So the one that remains is perhaps somehow doing a link from the nursing home to the court, with perhaps a duration of about an hour and a half, would seem to be, or maybe 2 hours with a break in the middle, given that if the bishop doesn't have to travel, then the fatigue would be less. The real question that arises, I suppose, is will the nursing home consent to this? I know that it's a Catholic Church nursing home. One would hope that they'd be happy to cooperate, given their... and those are something that it may be appropriate for Bishop Mulkhearns' representatives to look into that. But certainly, if it could be done at the nursing home, that would obviate a lot of the issues. It would remove a lot of the issues regarding fatigue and so on, because you wouldn't have that half an hour travelling at either end and having to go into court with the glare of the media and so on, all of those stresses, which then would lead, I suggest, to less fatigue and a better quality of evidence. But I suppose we really need to find out what the nursing home thinks about all of this, because they're the ones who are going to have to accommodate it.
Mr O'Brien.
Thank you, Your Honour. I'd endorse the matters put by Mr Shaw. The main development...
Don't have to accommodate it.
Mr O'Brien.
Thank you, Your Honour. I'd endorse the matters put by Mr Shaw. The main development for us today is that we have the first matter before the Commission, which is the confidentiality of the report. Having now perused the report and been careful not to overly transgress matters in the report, we would say in a very strong submission, the confidentiality of the report. Having now perused the report and been careful not to be subject to an ongoing confidentiality order, we would be content for matters relating to the physical health and treatment of Bishop Mulkhearns to remain confidential, but the sort of concerns that my friend had outlined relating to the physical health and treatment of Bishop Mulkhearns to remain Dr. Fonda, and it will be difficult for me to transgress these matters apart from referring to dot points from the treating Dr. Fonda, and it will be difficult for me to transgress these matters apart from referring to dot points without disclosing them themselves. That ought to be transparent, that does not in our submission, overly exposed the outcome of this application. In fact, they found the basis for the application in a way that ought to be transition of the bishop, how he sees his condition, how the doctors see his condition and how he sees the US. Quite the contrary. They explain the position of the bishop, how he sees his condition, how the doctors see his condition and how he sees the utility or otherwise of his evidence, and those matters are in a sense very self-explanatory. Picking up the point raised by Mr Shaw, they do also concede that there are potential facilities at the nursing home for the receipt of evidence. We're in the Commission's hands as to whether the bishop would be required or request a case that he is in terminal decline. Regretfully, it is an important opportunity for our strong submission is that whilst if it is the case that he is in terminal decline, the bishop as to particularly what he can recall, what he can explain, perhaps it may well alleviate some of his stress without, in a sense, endeavouring to transgress onto clinical matters. But if it is anxiety as a result of these matters, there may be the opportunity, if there are matters that the bishop, upon being prompted, which is what the nature of the report seems to concede, that on prompting he may recall the result of these matters. There may be the opportunity, if there are matters that the bishop, upon being prompted, which is what the nature of the report seems to concede, that on prompting he may recall things, it may be that the bishop's point of view, I'm coming from a practical point of view, it may be that the ability to provide some information to the victims who have long yearned for answers into these important matters, and for which we've heard witness after witness say orally they were matters that were only dealt with by the bishop. That opportunity should not be lost. Now that it has effectively been provided in open court by Dr Grace, we're in the Commission's hands as to whether a private session by commissioners only and counsel assisting, and we would be content with one commissioner to do that initially with counsel assisting. If we can't be there, it is obviously preferable to have the public hearing. And if a public hearing commences for an hour and a half at some stage, we would of course be concise in our questioning and mindful of the matters raised in the reports. I have in my copy circled paragraphs that I consider to be capable of disclosure, and I do tender those circled paragraphs. I can provide it to my friend, but they are matters that Your Honour can consider over the weekend.
I'm sorry,
they are matters that I do not consider raise any special medical reasons, rather they transgress in the matters that I've earlier
I'll receive it as a submission, and what we can do is the Commission officer in Melbourne can make arrangements for that to be emailed up to me this afternoon.
Thank you, Your Honour. And in doing so, I've done it fairly scantily. I've endeavoured to pick up matters that are important for the public record, given the position that Mr Grace has already placed on record, namely that Bishop Mulkhearns, as I understand it, had a stroke, has got colon cancer and is in terminal decline and is stressed about giving evidence. If those are the given facts, then the matters I've identified and circled ought to be now placed on the public record, irrespective of this application. And I conclude by urging the Commission to adopt whatever course it can be to obtain what evidence can be obtained from Bishop Mulkhearns.
Thank you, Your Honour. I find myself at odds with my learned friends in Melbourne. Having read the material, I have not sought for my instructor to obtain individual instructions from clients because it seemed to me not a matter for such instructions. Having read the material, it seemed to me that any hearing that could feasibly be held would be of little or possibly even no assistance to the Commission. The conditions under which the Bishop could give evidence outlined by Dr Fonda, the geriatrician, seemed to me to be practically unworkable. Now, I accept, of course, that that's not a judgment that I should or can make. That's your judgment. But I can't really see that any assistance could be gleaned from such a hearing. The involvement of Bishop Mulkhearns, as I said to you before, in the events that transpired in Ballarat decades ago, is abundantly clear from the material in the tender bundle. If there's something that's sought to be put forward in relation to that material, it can be put forward by those who represent Bishop Mulkhearns. But it didn't seem to me, as a responsible counsel, that you will get very much useful assistance from the sort of hearings that Dr Fonda outlines. The Commission, please.
Ms Finesse.
Thank you.
Your Honour, if I could rise just following Dr Hampson to clarify one matter. I agree with Dr Hanskin's assessment that the process of receiving evidence by Dr Fonda would not be our preferred process. If I could paraphrase that process, as I understand it also from Mr Grace's submission, namely that Bishop Mulkhearns be provided on notice of matters that he's effectively raised that process, as I understand it also from Mr Grace's submission, namely that Bishop Mulkhearns be provided on notice of matters that he's effectively going to give evidence about. I would actually believe and support that the submission of Mr Shaw, namely that cross-examination is fundamentally a matter where a witness doesn't get notice of the questions, is actually a preferable course, both for the practical reasons it would be shorter and counsel can confine the matters and therefore hopefully add some additional evidence of relevance and utility to the Commission's work. I do share Dr Hanskin's concerns that this may not some additional evidence of relevance and utility to the Commission's work. I do share Dr Hanskin's concerns that this may not be a fruitful exercise in that he may state of his potential decline. I do submit that it is an important matter of public importance that an attempt, and I'll leave the matters of how that be done, whether it be done by private hearing, public hearing, facilitated hearing at the nursing home, but an attempt be made to obtain some answers from Bishop Mulkhearns as to the matters that are live in his knowledge.
Dr Hanskin, as I understand her, is concerned that given the state of health of the bishop and his mental capacity, that oral evidence from him may not assist at all and may just tend to confuse, having regard to what she submits to be clarity with which the documents speak. Have you considered what she's had to say about that? Having regard to what she submits to be clarity with which the documents speak. Have you considered what she's had to say about that?
Look, in relation to that, perhaps this needs to be done sequentially. The other for a member of the Commission to, in a sense, obtain a first run of the evidence, which can sit on the public record, and on occasion, by consent, that evidence has been tendered. That was the course that I think Mr Shaw was endeavouring to outline to you. I would submit to your honours that that would be the practical first step, so that the most pertinent questions could perhaps be obviously identified by counsel assisting initially, and I'm happy on my behalf step, so that the most pertinent questions could perhaps be obviously identified to obtain, first of all, via counsel assisting, the matters that Bishop Mulkhearns may elicit some evidence on, and if a process initially were taken where counsel assisting obtains some evidence in a private hearing, then that transcript can then be assessed to see the utility of that evidence. That would be a practical step well in advance of the Ballarat hearings. We're also very conscious that the time of the Commission on those hearings is scarce and needs to be spent with utility, and that's why the private facilitation, with or without authorisation of Mr Shaw and myself and other counsel to attend as well, could be an initial first step.
Yes, I'm not quite sure that I'm effectively communicating what I understand Dr Hanskin to be saying, which is that whether you do it privately or publicly, effectively communicating what I understand Dr Hanskin to be saying, and may just confuse, having regard to the clarity with which the documents speak. Now, that's a risk for everyone, but it's plain that by reason of his condition, both mental and physical, that obtaining his evidence will be very difficult. Yes, we have heard from priests in private hearing. That very often is to explore what documents don't tell us, but also to assess the reliability of placing evidence in the public domain, having regard to what some of the allegations might be. There are different considerations, but what you're effectively asking the Commission to do would be to have a private hearing to assess whether we think his evidence will be of utility if placed in the public domain. Is that right?
I'm not sure what Mr O'Brien was saying about that, but as far as the reliability of the evidence goes, I submit that really Bishop Mulkhearns is in the position of any other witness in any forum, that that's something for the Commission to assess. If it became apparent very early on in his evidence that there was an issue about that, well then of course the Commission could take no further evidence or perhaps make an assessment, but really that assessment that's been made has been made by a doctor who I suggest wouldn't really be able to, based on what Bishop Mulkhearns told him himself, has been made by a doctor who I suggest wouldn't really be able to evidence at the base level, and then assuming that that person is competent to determine what weight is to be given to the evidence they give. And it may be that the evidence carries no weight, but there's no certainty about that. That's just simply something Bishop Mulkhearns has said, that how he feels about it. But depending on how he's questioned and what he's asked about, ultimately it's a matter for the Commission to decide, well, is this evidence reliable? And we can only find that out if the evidence is given.
Well, the second issue will be, given the time constraints which the doctor says we will have to observe in relation to Bishop Mulkhearns, you may find his evidence is spread over multiple days and over, accordingly over weeks.
Well,
because an hour and a half, given what we're told about his mental capacity, won't allow for too many questions to be asked and answered.
Well, I suppose some evidence is better than none. And if I could suggest that it really is incumbent on people in my position and Mr O'Brien's is to really focus on what it is they want to ask. And if I could suggest that it really is incumbent on people in my position and Mr cross-examination per party, and that may prove to be very effective. That the time pressure may actually become a positive, in the sense that everyone will say, right, well, what are the real issues here, and go straight to those.
Well, you leave out of consideration what counsel assisting may want to do, but look,
yes, of course, but
I understand what you say.
Yeah.
Dr. Hanscom, did you want to say something?
I think it was just cleared up then. I wanted just, in case my submission had been unclear, to make it clear, because my submission was the progenitor of that debate, that I'm not making a submission to Your Honour primarily on the basis of what the geriatrician says about the Bishop's cognitive state, but the practicalities, the second matter to which Your Honour referred, a hearing of an hour or an hour and a half and then a 3 or 4 day gap is simply not workable. And that was really the focus of my submission to Your Honour, rather than capacity.
Ms Finnis?
Thank you, Your Honour.
Sorry, Mr O'Brien, did you want to say something further?
Sorry, Ms Finnis. Sorry, Your Honour. I didn't get to conclude. To summarise, the first aspect we make is that the document should be released in a substantive way, in the way that I have now tended to your assistant to deal with this application one way or the other. I should then say we are primarily in the Commission's hands and Counsel Assisting's hands as to the evidence that Counsel Assisting wishes to present to the Commission and the manner in which that evidence ought to be pressed. Note in the concession that we have only received today that Bishop Mulkhearns is prepared to give evidence in some capacity, provided some mechanisms are available. And our submission, again, I haven't even obtained formal instructions of this, but our submissions really at first instance are to the effect that whatever attempt can be made to obtain some evidence ought to be obtained, and if that to be done in a progressive manner, as has been done with the other priests, so be it. We're very conscious that we don't want to interrupt what is already a fairly full book, and there might be time pressures also with Cardinal Pell the following week, and that's why I have identified the private hearing as an alternative. Obviously, it would be better to be in public, and I, for mine, am happy to be limited in time for cross-examination, and of course, and that's why I have identified the private hearing as an alternative. Obviously, it would be better to be in public, and I, for mine, am happy to be limited in time for cross-examination, and of course, counsel assisting, as has happened with many other witnesses, would be likely to cover much of the matters that we would wish to transgress and question Bishop Mulkhearns about. Simply saying in conclusion that whilst he is alive, that opportunity to question him about these matters and see what evidence he can provide should not be lightly.
Submission. It is the case that there is a deal of documentary material already before the Commission that details Bishop Mulkhearns' correspondence, his interview with CCI and various other file notes and the like that provide what was then contemporaneous evidence of various events. It is also in my submission, based on the medical records which have been provided, that it seems more likely than not that the evidence that is elicited will be less rather than more helpful, given the parameters set by those medical records. And in the event, as Your Honour has suggested that results in confusion rather than light being shone in any area that's relevant to the Royal Commission's work, it may well not be a useful exercise. Dealing then, if I can, with the question of whether or not there should be any private hearing or session in advance of any public outing. Firstly, as Your Honour's indicated, the private sessions, whether or not there should be any private hearing or session in advance of any public...
...makes plain it's not evidence. If you look at the Act, private session is not evidence.
It's not evidence. There's restrictions as to who should be there. There's restrictions as to what can be done. And in any event, it's a misconception as to the legislation to suggest it might be used in this context. In relation to a private hearing, it is clear that there is much public interest in Bishop Mulkhearns and him giving evidence. In my submission, there would be absolutely no utility whatsoever in holding a private hearing in respect of his evidence. His counsel in my submission, there would be absolutely no utility whatsoever in holding a private hearing in respect of his evidence. His counsel has indicated that he departs from the view of the doctor insofar as he is pressing for a in-camera or private hearing on the basis that it would be a more cooperative and participatory exercise. So there is no movement before you, Your Honour, to support a private hearing from those representing Mr Mulkhearns, and certainly I would submit that that would not be appropriate. The representative of Bishop Mulkhearns has indicated that a hearing of some sort could take place outside of the nursing home, and I think he agreed with Your Honour that the difficulties that might arise if it was within the nursing home would mean a more neutral location outside would be preferable. In my submission, that could easily be a courthouse, which is, I'm told, very close by, and it is neutral to the extent that it is not a school or something similar, or indeed a church. In those circumstances, there could be a public hearing held in a courthouse for the purposes of hearing his evidence publicly. All the necessary supports would have to be in place. were that hearing to be conducted along the lines set out in this report, it would be, in my submission, useless. The evidence that could be obtained would be of little benefit. There could be no proper comparison between the evidence that Bishop Mulkhearns gives and the evidence of other witnesses who have been examined without restrictions on their time or the nature of the questions, and by many people over a period of time not examined without restrictions on their time or the nature of the questions, and by, in my submission, the...
So what are you submitting I should decide?
In my submission, hold a hearing in the Magistrates' Court in Ballarat to hear his evidence over an initial period of 1.5 or 2 hours, assess the benefit of that evidence to the Ballarat case study, and then determine whether there's any utility of continuing to require him to give evidence. Otherwise, if that was not to happen, and given that those who are representing survivors, there would be, and I think reasonably, be considerable distress that there is an opportunity to hear from him, albeit perhaps over a short period, and that he himself is willing.
Well, if it could be arranged, would it be, in your submission, appropriate to do it with him remaining on a video link from the nursing home?
Well, bearing in mind...
Assuming the nursing home could do it.
Well, leaving aside the physical logistics and assuming that that can all be accomplished. Well, bearing in mind...
Assuming the nursing home could do it.
Well, indeed, it might be preferable not to be in the nursing home, given that that would indicate clearly where he lived, and there may well be a deal of activity outside the nursing home which would probably adversely affect the other residents.
So the alternative then is another courthouse which has a video facility?
Well, a video facility in the sense that those outside the courthouse could view it, but it could be, as normally is the case in Ballarat, the hearing would be streamed live as it ordinarily is.
Yes, but I'm not clear what you have in mind. Do you have in mind that Bishop Mulkhearns would go to another courthouse and it would be streamed into the Magistrates' Court in Ballarat?
No. Your Honour?
You have in mind that he would go to the Ballarat courthouse? Yes,
and that's, as I understood, the application ultimately was that he didn't need to be in the nursing home. If he wasn't in the nursing home, there's no proper reason for him to be anywhere other than a courthouse. And there would necessarily be ways in which the Commission could ensure that he came safely and left safely from that courthouse. That's something that's routinely done. And to the extent that each of the conditions which have safely and left safely from that courthouse, that's something that's routinely done. And lines. However, Your Honour, I do think there would be utility in seeking to understand from Mr Grace whether there are any other of the effectively conditions imposed by the doctor that he doesn't believe should be followed, given his reference to not supporting the in-camera part of the evidence. So I would ask him whether there's any other matters that he considers on behalf of his client not necessary for the Commission to follow.
Mr Grace?
Yes, so my understanding of the reference of Dr Fonda to in-camera hearing was a reference to trying to find a mechanism whereby the stress that he previously encountered at the Geelong Magistrates' Court could be avoided. That stress had a severe impact upon him and may well have another severe impact upon him if he encountered that stress at the Ballarat Magistrates' Court. So when Dr Fonda talks about an in-camera hearing, it's not to be equated with a private hearing within the meaning of that phrase in the legislation. What Dr Fonda could be taken to be talking about is a hearing within the confines of the nursing home. Now, as I said earlier, there's been no consent sought from the nursing home for the purposes of conducting a video link from there. But that can be sought, and certainly we would do that immediately today if there was an indication from you, sir, or the Commission that that was a viable option. But if I could just go back a step and to reflect on Dr. Hanscom's submissions and some commentary from Your Honour. The first issue to be decided upon is the question of usefulness to the Royal Commission of any evidence to be given by Bishop Mulkhearns, regardless of where that setting for the giving of the evidence may be. And if it's not to be thought that would serve any useful purpose, then my submission would be that he ought to be excused from any summons. But if the judgment is that it would potentially serve a purpose, then my submission is to maximise that purpose or the usefulness of the evidence. Arrangements be made so that he doesn't require to move from his premises, or if he does have to move, then it be away from the forum which would cause him the greatest stress. Can I just, does have to move, then it be away from the forum which would cause him the greatest from Bishop Mulkhearns. When I say difficulty, I'm not talking about any more than the cognitive impairment that Dr. Fonda describes in terms of its practical content, but I'm talking about in terms of him answering a question and finding the right word to insert in an answer. He does so with considerable slowness and considerable difficulty, and that pervades every conversation with him. Stress magnifies the effects of that problem, so that in a situation of the greatest stress with the greatest public glare, the problem would, in my submission, be exacerbated. So that the time period required for a normal question and answer session will be prolonged and elongated, and the time period required for a normal question and answer session will be supported by Dr. Fonda will necessitate frequent breaks. So it's a question of practicalities, it's a question of usefulness to the Commission, and Dr. Hanscom, in my submission, is correct to raise the issues she's made. There is an ample amount of documentary material in the case study materials of case number 28 to allow the Commission to come to a conclusion. And any evidence that Bishop Mulkhearns would give has the risk of causing the confusion and may at times, the answers may at times rather, be at odds with some of the documentary material that's been provided to date. So the question for judgment by you, Sue, is firstly the usefulness of him being called, and if it is deemed that it would be useful potentially for him to be called, then the question of ameliorating the effects of him giving evidence upon him and his medical condition and his cognitive functioning and his ability to answer in order to promote that usefulness. Those are the matters.
Yes. Is there anything that anyone else wishes to say?
By way of agreeing with the course outlined to you by Ms Finesse in her last submission to you, namely that it would be better to assess all these issues in a sense with the witness, Bishop Mulkhearns, facilitated whether it be via video link or directly in the courtroom. That can be resolved perhaps between Mr Grace, the nursing home, and counsel assisting. But from my client's position, as I understand his instructions, 2 hours, 1 or 2 questions will be better than never having any answers provided by Bishop Mulkhearns at all on the public record to these matters. And the utility can then be assessed.
Very well. Nothing further, Ms Fernandez?
No, Your Honour.
Well, what I need, firstly, is very quickly, Mr Grace, some indication as to whether or not the nursing home could accommodate a video link to the Ballarat courthouse. Now, if the nursing home can't accommodate, then if he's to give evidence, it obviously won't be there.
Could I'll arrange for immediate inquiries to be made and for the result of those inquiries to be communicated to Commission staff this afternoon.
They'll need to understand, the nursing home, that it won't just be a man or woman with a camera, but there'll be necessarily a number of other people and documentary material and so on that has to be located in the nursing home, and bearing in mind that the evidence as received would be broadcast through the internet effectively to anyone who wishes to watch it. The facilities in the nursing home would have to be amenable to the privacy necessary to ensure that that process is not one that is in the nursing home would have to be amenable to the privacy necessary that the process doesn't interfere with their normal activities.
Yes. Certainly those inquiries will be made and those details will be conveyed and we'll communicate the results of that to Commission staff this afternoon, sir.
Now, that's not to say that I in any way have made up my mind about what should happen, but obviously unless I knew that it could happen there, then I couldn't assess what you have to say.
Yes, I understand, sir.
Your Honour, one additional matter that my friend might like to consider with the nursing home is security. What they have in place at the nursing home in terms of security and what they might need were this to occur in the nursing home.
Yes. All right. Well, if you could do that and let contact the Commission so that I can be told what the position is, and at the same time I think counsel for the other party should be told what the position of the nursing home is, then I will, as I said in relation to Cardinal Pell's matter, I will sit again at 1:45 on Monday, and if there's a need to be for further discussion, then we can have in relation to Cardinal Pell's matter. I will sit again at 1:45 on Monday, and if there's a need... All right.
Would that also be by video link to
same
courtroom in Melbourne?
Well, I don't know whether that court's available on Monday, but there'll be some arrangement made.
Thank you, sir.
All right. Very well. Well, thank you, and I'll now adjourn.